All rise. The Court of Appeal in and for the 5th District of the State of Florida is now in session. The Honorable Alan Lawson, Chief Judge presiding. All persons having business before this court, draw near to the attention and you will be heard. May God save the United States of America, the State of Florida, and this honorable court. Please be seated.
Good morning and welcome to an oral argument session of the 5th District Court of Appeal. As announced, I'm Alan Lawson. Rounding out the panel is Judge Torpy and Judge Wallace. We have two cases. The first is criminal and the second is civil. And let me just ask, is Mr. Baez or anyone from his office here? Yes, sir. Okay, if you're ready, Mr. Baez. On the criminal cases, each side gets 15 minutes. And if you will, on the civil cases, it's 20. And if you're here as an appellant, there are no cross appeals. But if you're here as an appellant, the way it works is the clock will count down your entire time and the light will turn red when your time is expired. You're responsible for keeping track of your rebuttal time. If you use all your 15 minutes or 20, whichever it is, then you won't have any time left for rebuttal. So you're responsible for that. If you let me know at the start of your argument how much time you'd like to say for rebuttal, I'll set the clock so that when you're in your rebuttal time, the light turns yellow on the podium, which will help you keep track of that. The first case is Charlie ELY versus State of Florida. Mr. Baez, whenever you're ready to proceed.
Thank you, Your Honor. May it please the court, counsel. I will be reserving 5 minutes for rebuttal and focusing our arguments on claims 7, 8, and 9 on this case. This case is a case that relates to and was prosecuted on the principal theory. And as in many cases, when the prosecution proceeds under this theory, there's always the danger of running into a situation where you're defending a case that has a hard distinction between moral guilt and legal guilt. And I think in this case, and in this situation, it was especially important because of the scant evidence that was directly against Miss ELY in this case. Originally, the theory of prosecution was that
I read her confession. She appears to have acknowledged that she was aware that the victim was being lured to the house for the purpose of killing him, that he wasn't going to leave. She knew he wasn't going to leave. And there was somebody at the house that had a motivation to kill him, and that she knowingly participated in that by going to the street corner with, I believe it was Amber Wright, and essentially luring the victim to her house. Isn't that what the evidence shows?
That's an interesting point, Your Honor, because what is called as a confession is really not a confession at all. The theory of the prosecution was that she accompanied Amber Wright to lure Seth back to the home. But the actual evidence that was presented at trial was that she did not say anything or do anything. She just accompanied Amber.
Who opened the door and let him in?
Well, that happened much later, and what happened is Seth didn't actually come back to the home when they went there. Mm-hmm. They came back to the home, and Amber Wright began texting him, trying to get him over on his own. And that's an interesting point. This court, the focus kind of changed when we got to the direct appeal, where it wasn't, because it was established during JOA, the court...
The state's focus.
Yes, the state's focus, because the court made a finding of fact during the JOA argument that she wasn't part of the luring to bring him back to the house when she went. So now the issue was her opening the door. We were kind of thrown off by that during the direct appeal because that's not something that was ever argued previously. However, if we had the opportunity, of course, we would show on the record that there was no evidence. The only evidence that was submitted was that she was in fear. They came back to the home. Michael Bargo was angry, had a gun, and was threatening them that somehow he better get back to the house, but was more threatening Amber Wright. So in this scenario...
Well, you didn't answer my question, Mr. Baez. Who opened the door and let the victim into the house?
She opened the door, but there's no evidence in the record at all.
According to the confession, she knew he was being lured there to kill him, right? I mean,
She knew that that was Amber's intent. Now, there's
Well, it
nothing in the record.
Then it was Kyle and Michael's intent, right?
I'm sorry, Michael Bargo's intent, yes. But there's nothing in the record that says that she knew who was at the door. There's nothing, because it was later found out that she didn't know that Amber was texting him to come
It
over.
was her house, right? In other words, she had the ability to close the door and not admit him into the house, but she did admit him into the house knowing that he was going to be killed, right?
With a guy,
Principal?
while there's a man with a gun behind her who is angry at her for
That's a
being
jury-
unsuccessful.
That's a jury question, whether or not she was acting in fear and all that, right? I mean, isn't that, jury kind of rejected that theory, right?
I agree. However, but there's zero evidence that knows that she knew who was at the door and that she had any issue, there's nothing to show that she knew he was at the door and that he was actually coming in. It's just, she opened the door, he walked in. There was no evidence as to what discussion was had at the door. Did he see Amber and just start walking in?
When somebody knocks on my door of my house and I open the door and they cross my threshold, I can pretty much assure you that it's with permission that they do that. They're not crossing the threshold without my permission, right? Can't the jury infer that because it was her house and she saw him standing there and she didn't close the door, or she let him in? Isn't that a reasonable inference?
But we're creating an inference here. We're creating the
It's okay,
what-ifs in those
The state proves
scenarios.
cases all the time by inference.
I'm sorry?
The state proves criminal cases all the time by inferences and circumstantial evidence. That's all they have. Okay, well, go ahead and get into your post-conviction.
Yes, it does, but my point is that there's nothing in the record that suggests that she had any control over him entering at that
Well, you
point.
lost on that issue, so you got to move on to your post-conviction argument.
Yes, sir. The first issue on our first claim, which is claim number 7, is this interrogation of the detective that includes a scenario where he is talking as the ghost of the victim. It's kind of like the ghost of Christmas past, where he is now, which literally has no probative value other than to try and create some type of moral duty to the defendant that somehow she should have stopped it. She should have stopped this
The
crime.
statement, you say the ghost of Christmas past, obviously, even by your characterization of that, you're not saying that that was intended to be offered for the truth of the matter asserted, correct? The statements by the law enforcement officer took place after the confession on the record, correct?
Again, I have a hard time calling it a confession because all she agreed to was that she went with Amber to meet up with Seth. So yes, it happened.
She also agreed to, or acknowledged to understanding that he wasn't going to leave the house once he came to the house, correct? That was before this role-playing that you're characterizing as the ghost of Christmas past, correct?
Yes, it does. And under the Florida law, she didn't have a duty to stop a crime. This ghost scenario questioning kind of imposes that. Why didn't you stop me? Why didn't you help me? You could have called the police. You could have done these things. And morally, it's repulsive. But legally, it's not. Under Florida law, we have, there is no bad Samaritan statute that requires Miss Ellie to do something to stop the crime.
Mr. Baez, if you'd tried the case, what would have been your legal objection to the tactic by the detective that relates to the conversation with the dead victim?
Well, it's a simple case. You've got only one piece of evidence, which is this interrogation evidence.
No, I'm talking about, I'm zeroing in on ground 7.
Yes.
And your criticism of defense counsel for not having that either redacted or removed from the confession, admission, whatever you want to call it. What is the legal objection to this line of interrogation?
That it has zero probative value, and that its only purpose is to confuse the issues before the jury. The issues before the jury, it came out during voir dire that the jury had an issue with the principal theory and someone not having a duty to stop a crime. And in fact, the state capitalized on it during closing arguments when they argued that because she didn't stop it, there you know that she had the criminal.
I'm not going to buy that it doesn't have any probative value. I might understand an argument that its probativeness is outweighed by its prejudice, substantially outweighed. That's probably a better argument. So you think that a 9403 argument should have been made below?
Yes, sir. There's really the probative value of a ghost speaking to the defendant. You really have to sit there and contemplating, aside from the eeriness of how it would play out before a jury. I'm sure it's a great weapon in that sense. However, again, the trying to create a moral responsibility for her to stop the crime, for her to have reported it, it completely confuses the jury, and it's the very point that every jury faces whenever they're dealing with the principal theory. The trial strategy...
Let me ask you this, because you're almost into your rebuttal time, and I want to get to this. Assuming that you were right, that it was ineffective under the broad Strickland standard not to make that objection, when you get to the prejudice prong, how do you deal with the Chandler case from the Florida Supreme Court saying that if you raise something as fundamental error in the direct appeal and the appellate court finds no fundamental error, that you can't establish prejudice under Strickland for failure to object to those statements?
We would rely on our arguments of our reply brief, which cite Bruno, and I think the tests are completely different. The direct appeal is to see if the court erred, whereas there's a Strickland test that must be addressed in the actual 3.850.
So you think that portion of the Chandler opinion, and I think there's one other from the Florida Supreme Court, is incorrect?
Yes, that's our position, that
we understand we can't conflict with the Florida Supreme Court. We have to follow.
I recognize that, but what I do believe is that the standards of review are completely different. So therefore, it doesn't bar us being able to raise that, and that would be our position.
It doesn't bar you from being able to raise it, but it says as a matter of law you can't establish prejudice, and if you can't establish prejudice, I guess there's no way to prevail.
I think it's, as it relates to the being able to establish prejudice, since the standard is different and you're making the analysis as it relates to the cumulative effect, it clearly is relevant when this court decides, looking at this confession and all of the different red flags that were there, some type of objection should have been made to all of these multiple issues that were presented before it.
And then the last thing I want to do before you sit down is I want to make sure I understand, I think, what's the most critical part of what I think the panel's been referring to as the confession, and you've questioned that. Detective Bowie said, you knew when Seth came to the house and you opened the door for Seth that he would never walk out of the house alive. You're nodding your head, but I'm not getting any verbal from you. And then your client said yes. And then he went again and said, what was that? And she said yes. And he said again, you knew that Seth was never going to walk out of that house alive. Is that correct? And she said yeah. Is that accurate?
It puts a crystal ball in the head of the defendant here, that she is going to know exactly what occurs, when in fact you do not. And there's nothing in the evidence to suggest that, one, she was able to predict exactly and everything that was done. There was the issue of this confession. It's being called a confession, but again, that specific issue is taking inferences and suppositions and stacking them, that one, who's behind the door? Is it Seth, or is it someone else? Is it a neighbor coming over for some coffee or asking for sugar? Who is it? And two, what specifically transpired at the door? There's no evidence before this court or was presented in the lower court at trial as to what transpired when the door was opened. The door was opened, he came in, he saw his girlfriend there and addressed that. Did she say or do anything to encourage that? That's the issue here. So I think to impose some type of responsibility as to what a person could assume that would happen in the future or predict that would happen in the future really isn't a confession. I don't see that as a confession in that regard.
Okay, thank you very much.
Thank you. The other claims that,
You want to say some
You wanna
rebuttal
save some
time,
rebuttal?
Mr. Baez?
yes, I can reserve that time for my rebuttal. Thank you.
May it please the court, my name is Pam Kohler, I represent the state of Florida in this case. Just kind of, at least going to ground 9, he relies a lot on Jackson. Jackson was not even the law at the time that this trial was held. This trial was held in August of 2011. Jackson was not decided until November of 2012, so we didn't even have Jackson out there.
Well, Jackson supports your position, doesn't it?
Well, Jackson just, yes, because basically what the state had argued during Jackson.
Distinguishing point is that in Jackson, there was some sort of limiting instruction.
Correct. And that they found that it was error, and reversible error in that case. As far as ground 7.
What do you say about, what do you say about ground 7? I mean, it had a 9403 argument been made as to this line of questioning, isn't the probativeness here substantially outweighed by the risk that the jury is going to think that the moral wrong of not helping him equates to criminal wrongdoing?
But again, I think it's probative of what was basically being discussed here, is that she knew she could have said something. She could have just said, go home, go away, don't come, and he would still be alive today. If that's the argument that she's not.
She is, I mean, what Mr. Baez says is the law, right?
Absolutely.
Not under any duty.
No legal duty,
to warn
correct.
him or to help him or to protect him from what she knows is going to be a crime committed by some others, right? So
Correct.
the jury could certainly hear this and be a little sidetracked on it if they hearing this line of questioning, right?
It was like 6 questions out of an hour, over an hour long. I looked it up. It's 1 page of 132 pages of her statement to police. I don't think, I mean, as you pointed out, they'd already heard her admit that she knew when she opened up the door to him that he wasn't leaving, that he was going to die
And the
there.
only thing she said substantively, she said basically she didn't help him because she was scared. I mean, that's the sum and substance of.
Well, she showed some remorse, which I think you wanted to get that, I mean, I think you want to get that out to the jury, that your client has remorse for what's happened to this young man.
Well, I don't know why the state gets to put that on as evidence, though.
Well, the defense made the decision not to object, and part of it was because, I mean, we're here dealing with trial strategy. And he said, basically the tape itself established her denials of guilt. That was what he testified. And he said, I had to weigh between putting her on the stand to testify and running the risk of subjecting her to cross-examination. So these are things he wanted to get out through the tape.
He could have taken just that part out and.
Sure, but I mean,
Denial still would have been there. There were no relevant denials in that portion where the role-playing happened.
Sure, but again, I mean, this is, he's like, I'm just kind of presenting this, and it does show her that she has remorse. It does show that she's sorry for what happened and that she was scared, and that's why she did this. And I understand she said that more than once during the statement, but he then on, cross-examination of the detective, he basically pointed out, well, you can misrepresent the evidence to her, yes, you can, and you basically, how many times did she deny doing this? Numerous times, so I mean, he got that out because they saw the entire tape and showed her denying it more than once during that tape.
Let me ask you this question to a point that Mr. Baez made. Wouldn't you agree that when you get to prejudice, if you get past the ineffective assistance, when you get to prejudice, that the standard for a movement in a 3850 motion is lower to prove prejudice than it would be to prove fundamental error on direct appeal.
Well, of course, that's not what the Florida Supreme Court has found, but,
But if you just look at the test side by side, that it's a harder burden to prove fundamental error than it is to prove prejudice if you just take the...
well, I think, yeah, but I mean, here, essentially, we argued fundamental error, that's all we argued, on direct appeal, and I don't think he
I mean,
could...
as a matter just of logic, then why would it make sense to say that if you haven't met a higher standard and a more difficult threshold, that you can't come back and try to meet a lower standard and a lower threshold for relief?
I think just because you've had your shot at challenging this issue, and if you can't even show fundamental error...
So for example, if the state doesn't get a criminal conviction for something that could also be a tort, should the person not be able to go to trial and try to prevail in a civil case? I mean, the law is very clear that since it's a different standard, the civil claimant isn't. Well,
I mean, obviously, fundamental errors, it vitiates the entire trial. What you're trying to prove here is that there's a reasonable probability that the outcome would be different.
Right, which would be easier to prove than the very difficult standard of vitiate the fairness of the entire
True,
trial.
but even applying the standard that is applied in this case, because the judge did not rely on Chandler. The judge went to the prejudice prong, and number one, found that the trial strategy was reasonable, or not unreasonable, and then also found that he couldn't show prejudice because by that time she had already made the admission that she knew he wasn't leaving.
Chandler, there really isn't any analysis. They just sort of say it's one of a number of claims, and they say, well, we reject this claim on the prejudice grounds because it could have been raised, or it was raised on direct appeal, and they didn't establish fundamental error. So there's no analysis of the different burdens on the movement or the appellant. Do you think we ought to get a question to Florida Supreme Court to allow them to look at that issue, since it really, you've conceded, doesn't make logical sense given the different standards?
Well, obviously the state of Florida likes that ruling. In Chandler, they just say, because he couldn't show the comments are fundamental and direct, he likewise cannot show that trial court's failure to object the comments resulted in prejudice sufficient to undermine the outcome of the case under the prejudice prong. I don't know that this is the case really to do it in. Maybe if there was another case where the state, where the defense had been able to show that the prejudice prong, but wasn't able to show fundamental error, but here he can't show the prejudice prong. So I don't think this is a really good case.
Baez, that it is, even on the principle theory, it probably was a close case for the jury. I mean, they had some good arguments, the defense did. It wasn't a slam dunk, certainly, correct?
Right.
And you realize that if someone's convicted because they didn't act to intercede when the law doesn't require that, and that wouldn't be sufficient for a conviction, if the jury's thinking, well, she should have done something, and clearly she should have, and she could have done something. I mean, clearly she could have, that if that's the basis for the jury's decision, then, or it could have been, then there's a good argument that maybe they met the prejudice prong under Strickland, and maybe there's a reasonable probability that it could have been different. I mean, there's...
I disagree. When you read that statement, and she basically says, I knew when I opened that door that he wasn't going to leave there alive. And then the fact that she also lied, it wasn't just that, but then she also lied. She said she stayed hiding in her room because she was so scared of Bargo while they were burning the body. And then the neighbor says, no, I was standing out there talking to her, and she was laughing and talking. And yeah, you know how I know that was her? Because she talked about her husband being in prison, which is what she had talked about during her statement. So that all coincided that it was actually this defendant that she was identifying, not Amber Wright. And she also talked about seeing another male and female by the fire while she's talking to this defendant. So, I mean, it's not just that. There are other things that help to show that she was a little more involved than she wanted to pretend to be, and she wasn't quite so devastated.
Did the state argue this in closing?
I don't really remember them arguing that much. I reread the closing argument. They focused on her part where she admitted that she knew he wasn't getting away from there alive. That was their focus. It's not a very long closing argument.
I don't remember. Was there any, did any of the co-defendants testify at trial?
Bargo invoked his Sixth Amendment right and refused to testify. I don't think they called anybody else. She was the first one to go to trial because she would not waive speedy trial. So they still had to try Amber and Kyle, and then I think Justin Soto entered a plea, and then Michael Bargo, of course, got the death penalty later on, but she was the first one to go to trial, so there really wasn't anything the state could offer.
We tried Amber Wright yet?
They did, and she's been found guilty, and she's on a direct appeal right now. But I just don't think this is the case for bringing that issue before the Supreme Court, just because there is no prejudice prong here, and they haven't established the prejudice prong. Obviously, the burden is on them, not the state of Florida. With fundamental error, of course, the burden is on the state of Florida to demonstrate that there's no fundamental error, but thank you.
Okay, thank you very much.
To piggyback off of that last point, I would argue as well that no opinion was ever rendered in the case, so we don't know how far in the analysis this court was able to proceed as to the prejudice of that issue. But to answer Your Honor's question, the state did argue. The state said specifically, Seth's dead. She could have, and she would have stopped it. And that's how we know that she had the conscious intent that a criminal act be done. The state points out as well, there's all kinds of things that are layered within this confession, if you want to call it that, of drug use, of her husband being in prison, of this ghost of Christmas past, of co-defendants testifying.
Did the judge instruct the jury that mere knowledge that a crime is going to be committed does not place a duty on anyone to protect against it or something?
I do not know the answer to that, Judge. I do know that during voir dire, the court suggested that it may issue a special instruction because the counsel was concerned about the jury having an issue, and he was to remind the court of it later, and he just never did. On my last point, and I know I'm running short on time, the issue number 9 is distinguished by Jackson not only because of the lack of a curative instruction, but also that Detective Spivey testified that they were getting information from other individuals in the other rooms and utilizing that information in the interrogation tactics. And that's what I think that distinguishes specifically the differences on claim number 9.
Thank you very much.
Okay, thank you.